rise. Court of Appeals Division 1 is now in session. Good morning. Please be seated. Thank you for your patience this morning. This is the time set for oral argument in TEUFEL versus American. Our cause number 1CA CV150736. Counsel, we have conferenced the case before coming in this morning, read the briefs thoroughly, and are prepared to discuss the issues without too much of the basics. If you would bear that in mind when you begin your presentation, we'd appreciate that. We are being audio and video recorded today, and the recordings will be available for you online. Lastly, each side has 20 minutes for oral argument. The appellants may reserve as much time as you wish, subject to watching your own clock, and we're prepared to proceed. Thank you.
Thank you, Your Honor. Mike Raymond and my partner Dan McCarthy with the law firm of Raymond, Greer and McCarthy on behalf of Denny Teufel and Steve Guy with the Guy Law Firm. It's kind of a pleasure to be back here as you go through your career. It's nice to know that a case that I was involved in years ago has come back full circle. The advanced roofing case I was involved in 1989. So it's nice to know that I can still have a career 28 years later. Although this time I'm on behalf of the insured as opposed to I was representing U.S. F&G in that case. I'd like to start, there are three issues involved here, but I might as well start with the very first insurance policies that my client procured, the homeowners policies, which are referred to as the long look policies. I won't go into the facts because you've obviously read the briefs very well, but essentially Mr. Teufel was going to build a home on a lot next to the home that he had and move into it. He had to excavate the hillside in order to build the pad. That was done by a contractor, and it was done negligently, which caused the hillside to become unstable, caused rock slides over the years, and then later, after he ended up changing his mind and selling the property to Sedator, there was a substantial rock slide that did cause damage to the home. The trial court in the case when they were dealing with the long look policies, they questioned, their question was whether the faulty work may fix the date of the occurrence, and their conclusion was that it could not, relying on the advanced roofing case from 1989. Of course, the advanced roofing case, though, was far different than what happened here. We contend that the allegations of the Sedator complaint, which included a negligence count, alleged faulty work that undermined the slope, and that was a condition that worsened over time. And it was that incremental damage that occurred from the date of the faulty construction all the way up until the last landslide. And where do we come up with that contention?
Is that the damage that's really at the heart of the complaint against your client?
I think there is damage all over the place. There's damage to the property itself. There's also damage alleged to shore up the damaged hillside. In fact, a supplemental disclosure statement asserted almost $700,000 in damage to shore up the hillside, including rocks that had fractured, shotcrete, way beyond the initial excavation.
But
itself.
If no slide had resulted, no damage had been experienced tangibly, we'd have a very different discussion if we were just talking about a latent defect, wouldn't we?
Well, we would be talking about a latent defect. I think the fact that the allegations of the complaint allege previous landslides during the long look policy, and they clearly do that at paragraphs 12, 24, 25, and 26, that certainly informs us that there's a fair potential that that hillside was damaged. that it was undermined and that it was dangerous. Would it be the case, would it be a closer call if there weren't those previous rock slides? Perhaps. But here we're only talking about the duty to defend, Judge Schwan. So we're only talking about the potential for property damage during the policy. And where do we look to? We look to the complaint. We look to the disclosure statements.
Let me ask you, if there were no question about the duty to defend, and there were rock slides earlier when it was a different insurance company, does the previous insurance company have a duty to defend based on the rock slides, the previous rock slides?
Well, it's not necessarily the rock slides per se, because those rock slides, there's no contention that they caused damage to the home. In fact, at the time, that was Denny TEUFEL who owned the home. But I think the point is that the rock rock slides inform us that there was incremental damage to that hillside from the time of the faulty construction.
But that's kind of the problem, isn't it? And I'm sorry for mispronouncing your client's name, but he owned the home at the time. Let's assume the home was negligently constructed. His insurance policy would not be liable to defend him for liability for damage to himself.
Not to himself, but to another person. And there
was no damage to another person during the policy period. That's what concerns me. With regard to the earlier set of policies, there was no liability to defend.
Well, but the damage had occurred.
But this isn't a policy to insure against damage. This is a policy to insure against liability. That's where the duty to defend arises from.
Well, that probably could be a standing issue in terms of the allegations of the underlying complaint and whether or not there could be recovery for past damages that occurred prior to the policy. But
well, I think
if you damage property, if you dump gasoline on your property and then sell it, and the new owner finds out about it and sues you, you could be held liable for, and the carrier could be held liable for that prior damage.
But the language of the policy, I mean, you're speaking about sort of general insurance law. Here we have language of a policy we can read that talks about liability for bodily injury or property damage that results during the policy period, not conditions that arise during the policy period that cause damage later. And that's a legitimate claims made restriction in policy language. So aren't we bound by the express language of those policies?
Well, I would submit that American Family's only position here was that there was no property damage during the long look policy. And that's what the court agreed upon. The court agreed that advanced roofing applied. There was no argument to what you're suggesting now that there was no legal liability to Sedator, before the home was sold. That simply is not an issue.
Well, it is. I mean, we have to read the policy. So under the language of the policy, how can you guide me through a reading of it that would give rise to a duty to defend under these policies? And we haven't. We're progressing in our time. We haven't even gotten to the other policy yet. But if you want to argue for liability under these, show me where the language supports liability to defend for events that happen during these policy periods.
Well, we're talking about whether or not there's an occurrence, which is an accident, including exposure to conditions which results during the policy in bodily injury or property damage. I know that when I've been doing construction defect litigation for the last 20 years, particularly in the 90s and 2000s, any carrier that was on the risk from the time of the faulty work to the time that the complaint was filed usually would jump in and defend and take a time on the risk, even though some of those policies, some of those homes weren't sold. In fact, many of those homes were not sold at the time of the faulty work.
Well, the policies for contractors read a little differently from homeowners' policies, though. And I agree with you. In typical construction defect cases where you have a contractor's policy, that would make sense. But here we're talking about a different sort of general liability protection for a homeowner, and that may explain the difference in language.
I don't think the language really is any different in the CGL policy than in the homeowner's policy. We will pay up to our limit compensatory damages for which any insured is legally liable because of bodily injury or property damage caused by an occurrence by this policy. I think that's pretty similar to what you find in CGL policies.
I don't want to detain you too long on this point because you have another policy to discuss.
Yeah, I'll head on. It just seems to me, though, Judge, that, again, the complaint itself alleged incremental damage during that policy period, during the long look policy, and there was $700,000 in damage that obviously came later in terms of being disclosed. You don't usually find out about the damage until later, but it's not really a discovery policy. It's when the property damage took place. But I'll move on to the 82nd place policy because the issue there that we didn't prevail on was the court found that the contractual liability exclusion barred coverage. Now, during this time period, there were 2 landslides that caused damage to the Long Look home, and the buyer of the property sued based on a number of counts, including the common law duty to deliver the property free from defects in workmanship. It was a negligence claim, a tort claim. There was resulting property damage, including the cost to shore up the hillside as well. The American family refused to defend, relying on their contractual liability exclusion. We do not cover personal liability under any contract or agreement. Well, what does that mean? I mean, I think in first grade we understand what under is. I'll meet you under the swing sets or under the slide. You know, as we get older, you might say that, well, Larry Fitzgerald's under contract. Well, I think a reasonable insured knows what that means. It means there's a contract that's governing the relationship between him and the Cardinals. But here I would think everyone would have to concede that Mr. Teufel, who didn't have much choice in the terms of the language of the policy, we have to decide, well, why did American Family use under contract? Why didn't they use arising out of? I would contend that not even arising out of would get them out of the duty to defend the tort claim. But they use arising out of in various other places in the policy. It seems to me that under contract is quite narrow. The judge gave it a very broad interpretation, which I think we don't usually do when we're talking about interpreting exclusions under the policy.
And that may well be. You would agree that the language is sufficient to exclude coverage for a specific contract action. Related tort actions, though, you're claiming are subject to the duty to defend.
Yeah, I guess we'd have to figure out what related tort action is. I think if they really wanted to... Well,
there are negligence and fraud claims in the complaint. Those are torts.
Correct.
Right.
But what are the allegations underlying those torts? Do they have? Does it involve activity that's independent of negotiating a contract? What was the alleged negligence?
That Mr. Teufel, as a vendor, which he wasn't a builder, he had people build the home for him, but that he retained control over that excavation and negligently did it. The excavation was clearly done improperly.
So he would be liable even if it was someone else who entered into the contract, I assume is your position. Let's say he's more like a contractor, even though someone else sold the property. This was the negligence of someone who was supervising the excavation.
That's the allegation. So in this instance, it just seems to me, Judge, that if American Family wanted to exclude attendant tort liability, they would have said so in the policy, and I think they're obligated to do so. The thing about torts is that the hillside could have collapsed and scratched the window. The hillside could have collapsed and killed the board meeting of Senator at the home, the entire population. You just never know about torts, what can happen. In this case, there was substantial damage, but it was a negligence count. And
What if there was the breach of the covenant of good faith and fair dealing? Would that be something American would be required to defend?
Yeah, I often deal with covenant of good faith and fair dealing in terms of bad faith. I represent insurers or policyholders, and that's a separate, tort, but it has certain elements of contract. It's an implied obligation in every contract. I think that's a closer call. But here we have a pure negligence count. If they wanted to exclude that, they needed to tell the average insured that. And I would just suggest that, when you have a heading called contractual liability, that's kind of what you mean. You're informing the average person that we're not going to cover your contractual liability, but, a negligence claim, that's not excluded. Okay. If there are any other questions, I'll reserve a few minutes for.
You don't have to answer this now if you don't want, but if you'd like to discuss the business exclusion.
It seems to me, Judge, that the facts were rather undisputed. The judge certainly felt so. Mr. Teufel retired from his business activity in 2007. He intended to build this home on the Longlet property for himself and his wife. He hired a general contractor to perform the work. He changed his mind about moving into the house before completing construction, and then he sold the property to Sedator.
If you have a pattern of activity where you continue to build and sell homes for profit, but you don't intend to make that a business, you just intend to build beautiful homes that you might decide to live in, is the subjective intent really determinative?
Well, I think the trial court thought so, and I think
What do you think?
I'm sorry?
What do you think?
Well, I think at best it creates an issue of fact, doesn't it? Which, if that's the case, the best that can be said here is there's a question of fact about Mr. Teufel's intent, and then if it creates an issue of fact, there's a duty to defend.
Thanks.
All right. Thank you.
Good morning. May it please the court. My name is Lynn Allen. I represent American Family Mutual Insurance Company, which is the appellee and cross appellant in the case. May I reserve a few moments of time for rebuttal on the cross appeal?
If you, we typically don't do that, but I don't think you're going to have much to rebut, really. He's only got 3 minutes and 40 seconds left. So.
But we'll see.
Let's see how it goes.
That sounds good. So what I would like to do this morning is to really open myself up to answering questions that you might have of me regarding the three issues, rather than just regurgitate what we put in our briefs.
Sounds like a fair plan. Perhaps we should begin with the language arising under.
Arising under for the purpose of the contract exclusion?
The contract exclusion, because it does seem that there's a fair body of law out there suggesting that arising under is a narrower term than arising out of contract. There seems to be a spectrum of breadth of these exclusions, and arising under seems to be the narrowest.
Well, Your Honor, I didn't see where the appellant had cited any case law suggesting that arising under is more narrowly construed than arising out of. The trial court.
But and that's not dispositive, of course. But I suppose a plain language reading would suggest that arising under means if you breach a contract, if the contract provides for some sort of monetary payment. Obviously, you can't insure against that. That would be a bond, not an insurance policy. But to say that anyone who you have a contract with is automatically excluded from any sort of claim seems hard to cram into the language arising under a contract.
Okay, and we're not making a very general broad argument of that nature. I'm going to focus specifically on claims that are brought by a home buyer against a home seller. And let me explain why we believe that the arising under language is sufficiently broad to cover those claims. The first reason being that, the word under still is a somewhat broad term. It's a covering, it's under, so whatever falls under that contract. If American Family wanted to limit that exclusion to just claims for breach of contract, it could have done so by stating, we will not cover your personal liability for claims alleging breach of contract, or some language of that nature. American Family chose to use different words, which is arising under, as opposed to limiting it to just breach of contract claims.
Well, and I suppose one reason for that might be that you can be liable under a contract for more than just breaching the contract, right? There can be conditions that create liability under the contract without breach, and it may be that American Family wanted to make sure that those were excluded as well.
That could be one reason, and those, that language would be broad enough to cover contractual obligations that don't necessarily require a breach. But then turning to the specific situation here, where you have a buyer and a seller of real estate, absent the real estate contract, the question is, would Mr. Teufel have had any liability to CTEUFEL, and I hope I'm pronouncing that right, if there had not been a real estate purchase contract? And that's why we spent some time in our brief on this notion of the allegations made by CTEUFEL against Teufel solely arise out of the alleged status as a builder-vendor.
So you're equating arising under with the concept of but for.
But for, as well as, would there be a duty if there wasn't a contract between these two entities? And our position, and I think the trial court correctly noted that there wouldn't be a duty if there wasn't a contract.
I want to talk about that because I think one could get into an interesting argument under some recent construction defect case law about whether there's even a claim here that doesn't sound in contract. But we're talking about the duty to defend. And let's assume that there's no duty, that the claim is frivolous. Isn't there still a duty to defend and file that motion to dismiss?
If there was a duty to defend.
But you said there could have been no duty. I took you to mean a duty by Mr. Teufel to CTEUFEL, not a duty by American Family to Mr. Teufel, in your remarks a few moments ago.
Right, because the claims that were brought by CTEUFEL against Teufel require a duty of some sort.
Let's say there's no duty. Let's say that CTEUFEL gets it wrong. There's no duty at all, and it files just a bad, frivolous complaint. Doesn't the duty to defend still require American Family to get rid of that bad, frivolous complaint for Mr. Teufel?
If this exclusion didn't apply, and we're just talking generally about a frivolous claim,
but
yes.
You're saying there was no duty. Let's just say Mr. Teufel is supervising, actively supervising grading property, or is some way involved in the construction. Without that, the contract, he might not have owed any duty to CTEUFEL. So nobody disputes that. If the only, let's say he's not the person selling the property, but he was involved in negligently grading the property. Your suggestion is he owed no duty in that capacity to CTEUFEL, but that's the defense to that claim.
Right.
And I think Judge Swan's point was, well, that means the insurance company should come in and make the argument that he owed no duty, so you lose on that claim. But that's different than, did you have a duty to come in and make that argument that this is not a viable claim?
Yeah, I think we're talking about two different things here. We're talking about defending the claim and making that argument that there's no duty. What we're talking about is interpretation and application of the insurance policy to whether that duty to defend even arises. And because the basis of the claims being made against TEUFEL require a duty, and that only duty would arise out of the contract. It falls under the contract, and therefore there's no duty to defend.
Why does a claim of negligence in doing something arise under the contract?
Because negligence requires a duty, so the duty has to come from somewhere, and we argue in this case and believe the trial court recognized that the duty falls within the contract between the two parties.
Leaving aside now the substantive merits of what I'm about to say, because again we're talking about the possible frivolous complaint, right? If one wanted to allege against Mr. TEUFEL, you have a duty as a matter of Arizona public policy to avoid creating hazardous conditions that can damage people and property. And you breached that duty by having this excavation done improperly. We can say all that without a contract, right? Now, it may very well be that a good reading of all the Sullivan cases say, well, that's wrong. That's what I just said is legally wrong. But a defense lawyer would have to come in and make that argument, right?
Right. So you
I'm sorry to interrupt, but if the claim is pled to say you had a common law tort duty, not a duty arising out of contract, but a common law tort duty to do this right, and you also had a duty not to misrepresent the property tortiously to us, then aren't those claims independent of the contract itself? They might not exist but for the fact that this contract created a relationship, but the duties underlying them are independent of the contract.
That is potentially true.
Okay.
So those are the substantive claims that may and were not brought in this case. I mean, and going back to the but-for argument that the trial court adopted, that's the logical and reasonable interpretation of the contract. There would be no claims between these two parties if there had not been a real estate contract. And the language of the policies...
No contract claims, but there might be some tort claims that are unrelated to the contract. And if the supervision and negligent act in some way cause damage, I'm not making the I'm not getting the connection necessarily to the contract.
But it's our position that CTOR did not make any claims that were independent of the contractual relationship between the two. Now, remember, the contract exclusion doesn't depend on the title you put on the claim. So if you call it a negligence claim or you call it a breach of contract claim, that's not the end of the discussion. You look at the underlying claim. And all of these claims that were pled, whether you call it a breach of the implied covenant of good workmanship or negligence or fraudulent representations, all of those claims depend on there being this contract between the two entities, and the plaintiff in the underlying case wouldn't have a claim but for the contract.
I went with you, though, on the negligence-based claims. How do you say that fraud arises out of contract?
Because the fraud was in connection with the sale of the property under the sales contract.
In connection with, I'll grant you, but under?
Well, one of the requirements of the contract is to provide truthful information as required under Arizona law. So that's part of the contractual obligation between the two. The seller's disclosure statement requires disclosure of certain matters, and as alleged in the complaint, one of the things that should have been disclosed are these alleged pre-sale rock slides. So,
well, I agree. Those get closer. The covenant of good faith and fair dealing, duty to accurately represent the property. But I'm not sure how. If he was the one sitting on the bulldozer doing the excavation, and he was just negligent in doing that, is that still a matter arising under contract?
That particular scenario, I don't believe would arise out of contract because it doesn't depend on his status as the seller of the property under the contract. And then there may not be a cause of action for that. I think that's a problem. But we've already touched on the fact that
can't we read the complaint to be alleging something along those lines? Actions that you may not believe to be very actionable or very, but that goes to the defense on the merits. And here we're just looking at, are you required to provide a defense and come in and say, well, he didn't owe you any duty if he's sitting on the bulldozer. But that doesn't suggest that the under contract exclusion applies.
Yeah. I just want to observe that I think each of us in this discussion has at least one moment slid into using the word arise out of, or the phrase arise out of, because we're talking about this general relationship to contract, and it's natural to make that mistake, but it's a mistake because the contract says arise under. And so I have to ask whether our predisposition to do that is masking the difference between those two phrases, or if you contend there is no difference.
I contend there is no difference. I believe the word under, arising under, is functionally equivalent to arising out of, and the trial court agreed.
The excavations took place before there was a contract, right?
I think there might have been some overlap. I know that in terms of the timeline, the contract went into effect in 2007, and I think the excavations were 2007 and 2008. I wanted to turn, since I have some time here, to the business pursuits exclusion, which is our cross appeal. And one of the things that was interesting was the hypothetical of, well, if he was riding the bulldozer and did this personally, what impact would that have on the contractual liability exclusion? Well, it does. That scenario and those allegations in this complaint that he was a builder vendor have to do with the business pursuits exclusion to a certain extent, because in order to be a builder vendor, or in order to be liable as a contractor, that necessarily means that you're conducting some sort of business activity, whether it be part-time or full-time. So going to the actual language, the exclusion is for property damage arising out of business pursuits. The definition of business is any profit-motivated full or part-time employment, trade, profession, or occupation. And key here is this notion that it could be full-time, it could be part-time, and where we think that the trial court got this wrong in denying that aspect of our cross motion for summary judgment. There's two reasons why we believe the court was wrong. First, the trial court actually didn't consider certain of those material and undisputed facts. And you may remember the court had determined there were no undisputed facts presented by either party in connection with our motions. We believe these facts that the court did not address in the minute entry,
Facts?
they were undisputed facts.
They were all undisputed. Okay.
They were undisputed.
I was tracking you.
But there were 3 or 4 key facts that the court did not consider in determining whether Mr. TEUFEL was involved in a business pursuit when he sold the house. Those facts are that TEUFEL frequently dabbled in real estate investments with Carmel Homes. He invested in both vacant lots and custom home construction. He invested in homes that generated rental income.
If I could interrupt, how would that go to if he's sitting on the bulldozer and doing that work and just decides at that point, is he in the business of excavating? If he just wants to build his own home and he's planning to live in it, is he in the business of being a home builder or being in the excavation business?
Yes, and the case I'm going to refer you to that we cited in the briefs is Dillig versus Fisher, and that case did not address insurance cover, but it did address whether one was a builder vendor under Arizona law, and that would consider similar factors that the court would have to consider here, which is whether or not you're in the business of building a home. And in that case, the plaintiff did just what Mr. TEUFEL did here. He bought a lot. He decided he was going to build a custom home on it. And during the course of construction, made a decision that he wasn't going to move into the home after all. And the intent in building the home was that he was going to live in it. During the course of construction, he decided, I'm not going to live in this home. I'm going to sell it anyways. And like Mr. TEUFEL, he was someone who, built and sold homes to make money. And the court in that case said that, the fact that he initially intended to live in the home did not preclude a finding that he was a builder vendor because there
are all sorts of undisputed facts on the record here that could lead to the conclusion that he's a builder and engaged in a business pursuit. I understand that. But on summary judgment, the question isn't whether there's an absence of a genuine dispute of fact only. It's whether the undisputed facts on the record compel a conclusion as a matter of law that something is true. In other words, no reasonable fact finder on this record could find anything other than that he was a builder vendor. And that's where I'm maybe slipping a sprocket on your analysis. Because I think a reasonable fact finder might look at these facts and say, he was trying to build his own house, even though he likes to build houses. If you acknowledge that a reasonable fact finder could say that, then is it a summary judgment question?
Okay. I don't agree that a reasonable fact finder could draw that conclusion based on these facts. And the key fact I'm talking about is the point in time where he decides, I'm not building this home for my personal use, but I'm going to build it and sell it to someone else, consistent with, his other business activities of a similar nature, this pattern of buying lots, building homes, and selling them. At the time that house becomes a commodity for sale, as opposed to this intent to live in it personally, that's where the construction of that home becomes a business pursuit as opposed to a personal.
Was there any evidence that the construction of the other homes was that he intended to live in them?
The other homes, there was no evidence presented by Mr. Teufel to that
Right, but
effect.
there's no evidence that the pattern was, oh, I'll build this house, I'll live in it, and then I change my mind. This is the only one where he says, I'm going to build this for myself, and then changes his mind.
In the record, that's the only evidence that was presented to the trial court.
And so if I look at it and say, well, I'm just not sure, based on the information I have right now, I'm a reasonable person. I mean, couldn't some reasonable person find contrary? I'll grant you there's a mountain of evidence that means that success at trial might be unlikely. But is that the same as saying summary judgment must be granted?
I certainly don't want to suggest that you're not a reasonable person.
I didn't mean to put you in that position, but I'm just suggesting.
But it's an objective standard, not a subjective standard, in terms of whether a reasonable jury would
The objective standard, I think, though, is whether any reasonable fact finder, including one who would disagree with me, could come to an opposite conclusion, or whether the opposite conclusion is just so far-fetched that you'd have to be patently unreasonable to come to that conclusion.
Well, I would just circle back around, Judge Swan, to the fact in the case of Dillig versus Fisher, which held that the fact that Mr. Fisher changed course during the course of construction and decided that this was going to be a home he was building for sale. I would have to go back and look at the case. I suspect it was a summary judgment case. And the court held that fact, that he initially intended to live in the home, did not preclude a finding. And we'd have to look at the case.
Was there any testimony that he changed his mind before the excavation was done or before construction? And if you have his testimony that just says, saying, I was planning on doing it, your position seems to be that you have to disbelieve him, which seems like a factual issue.
No, I'm not. And to answer your first question, I don't believe there's any evidence that was in the record as to whether or not he decided to sell the home before or after the excavation, so that's not a fact in the record. As to the other, I'm not asking you, and I didn't ask the trial court, to disbelieve that he initially intended to live in the home. What I'm saying is that under Arizona law set forth in Dillig versus Fisher, that fact is irrelevant to the issue of whether or not when he sold the home he was engaged in a business pursuit.
Are we all engaged in business pursuits when we sell our homes? I mean, most everybody who buys a home hopes someday to make a profit from it. And eventually most of these homes are sold. Are those all business pursuits?
Not under the scenario you pose, because that would not be a full-time or part-time occupation. If I'm selling my home just as, lawyer who owns a home, and I sell one home and I happen to be lucky enough to make a profit, that doesn't mean I'm engaging in a business pursuit.
What if you're fickle and you move every year? And it's really, you're living there, you're just enjoying the variety of different neighborhoods. Is that a business?
That could be a fact question. It could be a business, it could not be a business. It's going to depend on all of the facts. But what we have in this case is we have somebody who admittedly was in the business of building and selling homes, and he wants to, he builds and sells this home as well. And so that's a different scenario than a personal homeowner buying houses and selling them and, maybe doing it more than once in their lifetime. This is somebody who actually engaged in this business pursuit of building and selling homes to make a profit. And those facts were undisputed. The other thing I just want to point out, because I see that I'm out of time, there was the other reason why the trial court's decision was incorrect, and the trial court found that the business pursuit had to be engaged in during the policy period, so that would be during the 1 year of this policy period from 2012 to 2013. We cited to you a case that says no, it's not limited to business pursuits within that policy period. If the occurrence happened, or for at least here, the sale of the home, the building and the sale of the home happened outside of the policy period, this exclusion would still apply. And I also need to correct something that Mr. Raymond said on the record, which was that the 2 rock slides after the sale fall within the 82nd Street or 82nd Place policy. Only one did. Okay. The policy was not in effect in November 2011.
Thank you.
Thank you.
Thank you, Your Honor. Let me try to correct maybe a misunderstanding, maybe not, but I just want to make sure we're all aware of the precise language of the contractual liability exclusion. There was some reference to the rising out of language. Doesn't appear in the policy.
We know it's arising under.
No, it's arising under. Arising is not in the language.
It's just under contract.
Just under, yeah,
right,
okay.
Right.
And
let me ask a quick question. Factually, the excavations take place, any of the excavations take place after there was a contract between TEUFEL and Senator?
I don't think that's the case. The excavation took place in 2007, and I think it's after that time. I hope I'm not misstating anything, but I think it was well after that time that Mr. TEUFEL, who was going to, I mean, this property took a long time to build. Right. I think it was the long look policies were 4 years. Okay, and then the 82nd Street policy when he moved was 2011. So and
the sale was in.
I think it was in 2011, but
the sale I think was in 2011.
Correct. So 4 years after the excavation. Yes, and
be under a contract if there was no contract.
Right. Well, and there's tort liability. Like I said, the senator could have had a board meeting with 12 of his best friends there, and they could have died in the landslide. How could you say that that's a contract?
Right.
Contractual liability.
I guess what I'm saying is, usually we think of under contract as being you contract with somebody, you breach the contract, or you do something that's in violation of the contract. If I do something like do some excavation, and I don't have a contract with a seller, with a buyer, because I want to live in the house. I do all the excavations. I start to build the house. I decide, change my mind. I find a buyer. I sell it to him. How does that become a liability under contract?
Well,
yeah,
it doesn't.
Right.
And neither do the fraud claims, really, because they're tort. But and again, even more so, I think, as a reasonable insured, because the tort liability can be limitless. You could have killed people. Okay, here it was just property damage. Okay, nobody got hurt, but I mean, it's significant. If you're going to exclude that, I think you need to say something more than even arising under contract, which isn't even in the language. So, and as far as the business pursuits exclusion, really the facts that I asserted were unchallenged in the trial court, and that's why the trial court found as she did. But again, I would submit it the best case scenario for American Family. It's a question of fact. So, I have 30 seconds left unless there's any questions.
Okay, thank you very much. Thanks to both counsel for your arguments. It's an interesting case. Arguments are very helpful. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.